Welcome, friends, to the Probate Nation. My name is Richard Ruddy. You know, firearm ownership is very common in the United States. Since the mid-1980s, there have been tens of millions of firearms either manufactured or imported into this country. So there is a good chance you will discover your loved one owned one or more firearms at the time of death. But the presence of guns in an estate should be an immediate red flag to any executor. Actually, it should effectively set off one of those warning bells like you hear going off in an action movie when security is breached at a secure government facility. When the alarm starts ringing, it is important to know what to do to stay safe. We are fortunate to have as guests tonight attorneys Dan Peterson and Ben Inman. They are intimately familiar with the law of firearms. Over the course of 2 shows, they will share with us steps to take and pitfalls to avoid in the course of handling and probating firearms in an estate. Let me tell you a little bit about Dan and Ben before we get started. Dan Peterson is an attorney in Fairfax City whose practice consists entirely of firearms law. He represents individuals, companies, and groups in firearms, regulatory matters, and Second Amendment cases dealing with the right to keep and bear arms. He is a member of the bar in Virginia, D.C., Texas, and Iowa, and is admitted to practice in most federal circuit courts of appeal and the United States Supreme Court. Benjamin Inman is the founder of Inman Law in Tyson's Corner. His practice focuses on estate planning and administration, including firearms and cryptocurrency-related matters. He's a member of the National Academy of Elder Law Attorneys and the American Gun Owners Alliance. Please welcome Virginia attorneys Dan Peterson and Ben Inman. Gentlemen, welcome, and thank you so much for taking the time to chat with us for a couple of minutes today. You know, as we get started, let's go to the types of firearms. Let's kind of begin there. Ben, can you sketch out for us, for our viewers, some of the firearms that folks might very well have in their home?
Sure. So it starts out with the most basic kind of firearms that people are used to: rifles, shotguns, pistols. Then it can move into other less common items such as machine guns, short-barreled rifles, short-barreled shotguns. So there's really a wide range of different firearms that are out there in circulation, and knowing what you have is very important.
So we have posted up online there on the screen a kind of list of some of those firearms for our audience. So, is it important? You mentioned Ben, it's important to know the type of firearm that you're dealing with. So explain to us why that's important.
So it's important to know the type of firearm that you're dealing with because different firearms have different requirements. Rifles and pistols have different rifles and shotguns have different legal requirements than pistols, for instance, as well as, which is different from NFA items such as machine guns, short-barreled rifles, and short-barreled shotguns. What I mean by NFA items is National Firearms Act items. There's a special regulatory structure at the federal level for those items, separate and apart from your kind of ordinary firearms that people are going to be more used to.
So I know, Dan, I'm going to turn to you. Knowing what type of firearm you're dealing with as you begin to probate an estate is important for a whole bunch of reasons, which we're going to get into. But what is the best way at the very beginning to determine what type of gun you're looking at?
Sure, that's an important question. And I would say probably the best means of doing that in most instances is to take them to a local gun dealer. There are licensed, federally licensed dealers. And anybody who's advertising guns for sale, commercially has to have a license like that. And so they usually have a pretty good grasp on all the different types of firearms, and they can tell you if there's something that is out of the ordinary there that needs some kind of special treatment. Alternatively, you could try to find a collector or a firearms expert. And it's also possible too, depending upon your family, some families have people who are, weapons enthusiasts and have a pretty good knowledge of firearms. So it kind of depends upon what you have, but a dealer is probably best.
And so let's kind of turn then to the laws that govern firearms. I know we talked about this during I was really educated to the nth degree by you guys. There are a slew of federal and state laws governing guns. So I know we're going to get into some detail, but can you just identify briefly those laws, Dan, that are going to have an impact on what we do with these guns and how we handle them?
Sure. Like you say, it's both at the federal and state level. And Ben mentioned the National Firearms Act of 1934. That's the one that regulates machine guns and the like. That's a pretty complex system that requires a lot of paperwork for these specialized items. Other than that, the Gun Control Act of 1968 at the federal level is the basic regulatory framework. Like I say, you have to have licensed dealers. It prescribes certain things that are legal and illegal, illegal and how you can transfer firearms and can't transfer them. A lot of very specific rules. Then there's state law. Virginia has, of course, laws which govern firearms, possession, transfer, carrying, all those types of things in the state. And then if there's going to be a transfer of any estate firearms to someone out of state, then the laws of the other state have to be taken into consideration also.
So briefly, Dan, what are the most common guns that you see people have that are governed by the National Firearms Act of 1934?
Yeah, probably the most common right now. There are hundreds of thousands of these out there, by the way. And one category is increasing rapidly, and that is silencers. They've become very popular in recent years, and many silencers have been registered. They're actually considered a firearm, in quotes, under the National Firearms Act. So those need to be looked at and handled carefully, even though they can't shoot by themselves. Apart from that, you have fully automatic weapons, machine guns, so-called, type of firearm that if you pull the trigger back, the gun keeps firing until you release the trigger or you run out of ammunition. Then there's special regulations for short-barreled rifles, short-barreled shotguns, and a few other, small items. And the length for a rifle, if it has a barrel less than 16 inches, and for a shotgun, if it has a barrel less than 18 inches, and overall length less than 26 inches, then those are considered to be short barrel.
Okay, so Ben, I'm going to go to you. What guns are governed by the Gun Control Act of 1968?
So that's going to be all modern firearms that are expelled by they expel a projectile by means of an explosion. So it's basically everything. It's got, because you're talking about the gunpowder igniting and propelling your actual bullet down the barrel of the gun and down range, any firearm that works in that way is going to be subject to the Gun Control Act.
Now, Dan, are there guns that are not subject to these laws we just talked about?
Yes, there are some, and some of them are actually pretty common. The biggest exception, I would say, is for antique firearms. These are ones that are manufactured in or before 1898. And one of the criteria there is that if it uses what we call cartridges today, a brass cartridge with a bullet seated inside of it and gunpowder inside the cartridge, then there has to be no commercially available ammunition for it, which is a pretty hard condition to meet because specialized manufacturers oftentimes make a run of things for these more or less obsolete guns. But the one thing that is definitely not considered a modern firearm is muzzle loaders. Those are the kind that if you watch a Civil War movie or a Revolutionary War movie or something like that, you have to put the bullet down the barrel of the gun and then put it in place with a ramrod. Pour the gunpowder down first, of course, before the bullet, and then ram it down there and then shoot it. You don't actually have a modern metallic cartridge, which typically loads from the rear of the gun. So muzzle loaders, and including modern muzzle loaders, a lot of those are the replicas. But if they operate in the fashion I've just described, they can look a lot like modern guns. They can even have scopes on them, be made out of stainless steel, all that sort of thing. So those are exempt also. And also, generally speaking, in Virginia and federally, any air guns. BB guns, pellet guns, that type of thing, even though there's some air guns out there that are pretty powerful.
Ben, I'm going to go to you now. They're going to post up on screen some of the firearms that are subject to the National Firearms Act. But let's talk a little bit about the key obligations in order to own a firearm subject to the NFA. And can you tell me a little bit about that? How do you become an owner?
So there are two ways to become an owner of NFA firearms. One is to file a Form 1 with ATF, which is the request to make a NFA item. Once you receive a response back from the Bureau of Alcohol, Tobacco, and Firearms approving your ability to manufacture that item, you can make it, or the more common way is to purchase an NFA item from a dealer, and you file, instead of a Form 1, you file a Form 4, and you go through a similar process where you wait for ATF approval for your ability to possess that NFA item.
So, and of course, I know we've talked about this, but in order to own the gun, you still have to go through a bunch of complicated printed forms, you got to get your photo taken, fingerprinting, and local law enforcement clearance and stuff like that as well. Now, you get that paperwork. Is that paperwork important to retain?
Yes, absolutely. So one of the conditions of being able to possess NFA items is that you have to have the tax stamp, because there's a $200 tax stamp that goes along with either the Form 1 or the Form 4, and it's literally a stamp. It looks like it's very similar to a postage stamp that goes on the top of the form, and there's usually some writing over the tax stamp to authenticate it to the firearm, so nobody goes and starts trying to switch tax stamps around between different forms. But that's the process. The one thing I did want to add is, so you don't need permission from local law enforcement anymore. That was a prior requirement under the NFA. Now it's merely notice. That was changed a few years ago.
Okay. Dan, I'm going to come to you. So are there any adverse consequences if I don't have that paperwork that Ben mentioned, but I have the gun in my possession?
There are severe adverse consequences, up to 10 years in prison and very, very hefty fines. And
so if I don't have it and I realize I don't have it, can I get copies of that to prove my registration? Can I get that from the ATF?
Well, I've never tried it, but I would think the answer would be yes. And if we're talking about an estate, it would probably have to be the executor of the estate that attempted to get that paperwork.
Okay. So if I have, and so just so I can keep sort of on the same form, I know there's a Form 5 we talked about, pardon me, Dan, and I understand that that's the form, if I'm the executor of an estate and I want to transfer a firearm, that's the form I'm going to need to prepare and file. Is that correct?
Yes, that's true. And the advantage of using a Form 5 is that there's no $200 tax. The transfer takes place for free, so to speak. You still have to file that form with ATF, and they still have to approve it before the actual physical transfer of the firearm can take place. If the firearm is going to an heir, that's the form you use. If it's going to somebody else, if the executor just decides, well, I'm just going to sell this gun or these guns, then you'd have to use the Form 4.
Okay.
And pay the tax.
Ben, I'm going to come to you. We talked about Form 4. I'm going to kind of jump ahead. So I'm the executor of an estate. If there is a gun subject to this statute, what would you recommend I do before undertaking to sell this gun to a third party or deliver it to an heir? What would you recommend I do?
Well, number one is complete the paperwork and submit it to ATF. Retain possession of the NFA firearm or NFA item until you receive the approval from ATF. So submitting the paperwork is not enough. It is not a lawful transfer until ATF has cashed the check and approved your paperwork. Only at that point can you then transfer the NFA item Until then, it remains in what's kind of commonly called NFA jail. Your items held at the dealer, or in this case, the executor continues to hold on to the item until ATF approves the paperwork, which can vary significantly depending on when it happens.
So Ben, thank you for that, the answer to that question. Dan, I want to go to you. Can I sell the gun? If I have this gun, I've done the paperwork, what should I do? What do I need to do to make the sale legal?
Well, there's a new law in Virginia where if there is a sale of a firearm to anyone, they have to go through a background check. The purchaser does. Go to a dealer and have a background check done. That's new. You didn't used to have to do that. Same process for NFA firearms, and this is only for buyers and sellers who are Virginia residents. If you're going to transfer the gun, sell the gun to somebody out of state, then you have to have it transferred through FFLs, licensees.
Thank you very much, Dan. Ben, I'm going to come back to you, and we're going to start to talk about some estate administration issues. Now, I know we've talked about there are rules regarding executors and whether or not they are even allowed to handle guns. I guess they fall under this definition of whether or not the executor is a prohibited person. Now, we chatted about this. There's a whole list of these types of people. I know there's a list that we can look at that's available at the Virginia State Police website, but can you name a couple of these key prohibited people that are identified in that list that we're going to find?
Sure. So, Richard, the most common ones that are prohibited people are convicted felons or people convicted of domestic assault and battery, or what we call in Virginia domestic battery of a household or family member. There's a whole slew of other people, people who have renounced their citizenship, dishonorably discharged from the armed forces. There's just a whole slew of different categories that are also included as prohibited persons, but the two most major ones are the convicted felons and those convicted of domestic assault and battery.
So Ben, I understand the importance of the prohibited person rule and how it applies to an executor. And I gather from our discussion in preparing for the show that it also applies to all firearms. So as we follow the bouncing ball here, does that mean that the prohibited person rule also applies to the recipient of the firearm, the beneficiary that might be receiving it pursuant to a bequest?
Absolutely, Richard. So under these prohibited person rules, the crime is possession by a prohibited person. So if one of these prohibited people comes into possession of a firearm or its ammunition, that's a separate felony under both state and federal law here in Virginia.
Okay, so we want to be careful about that because we don't want to trigger a felony or any sort of penalty of any kind. Now, before I leave this area about state administration, Ben, I know gun trusts have been very popular over the last several years. I know you've been involved with that for a number of times. Tell me a little bit about what is the purpose of a gun trust?
So the purpose of a gun trust currently is that you can have a NFA item that is able to be possessed by a few different people rather than just a single person. So normally if someone buys a suppressor from a dealer and they want to go and say they want to let their son go out hunting with their suppressor, they can't do that because that transfer from father to son is a taxable event that requires a new form. However, if both the father and son purchased the NFA item, the suppressor, through a gun trust, because as long as those people are both on the gun trust as people who are able to possess the item, there's no transfer that occurs as far as the National Firearms Act is concerned. So no taxes due, and there's no additional Form 4 taxable transfer that occurs, and so they're just able to share that item between them without having to worry about changing the paperwork every time they transfer the item.
Okay, well that's good to know, and I do understand that they do work for a limited purpose. You know, Dan, I'm going to come back to you now and begin to talk about the actual transfer of guns and the transportation of guns. Okay, so are there rules that govern the transfer of guns to a buyer and an heir or an heir?
Yes, and some of those are state laws and some of them are federal laws. State laws include the one that I mentioned about having background checks done. That's only, but from an estate, if there's no charge, if it's not a sale, if nothing of value is exchanged, then you don't have to do that background check. Also, Virginia has a one handgun a month law, which prohibits people from purchasing more than one handgun a month. Whether it applies to receiving firearms from estates is not clear. It doesn't address that issue, but it speaks of purchases again. So there's a good case it could be made that it doesn't apply. On the federal side, it's illegal for private individuals who are not licensed to either transport guns across state lines, transfer is what I mean, to another person where they're going to keep the gun, or for a person who's not a resident of the same state to receive a gun. However, there's a special exception for bequests of firearms, which allows that to occur. So you don't have to go through an FFL ordinarily if a beneficiary of the estate is going to receive the firearm in that state. If it's going to be a sale or a gift to someone who's not a beneficiary of the estate by the estate itself, then you would have to observe those rules.
Now, so the other thing we want to talk about, you're talking about transferring. I think you hit on a good thing about how estates have a little bit of a room there to maybe to do things more efficiently if the beneficiary lives in the state of the probate estate. But how about if I have to transport that gun? You know, can I transport that gun across state lines from Virginia to D.C. or from Virginia to Maryland or Virginia to New York, for instance? You know, do I have anything I need to be worried about there?
Well, you can do it in the sense of having a transfer to a beneficiary of an estate. You can take it there yourself, but you have to be careful because there are some states that are very restrictive in their gun laws, and they will enforce them against you if you're just even passing through the state and you don't have proper permits and so forth for the gun in that state. There is, however, a federal law which purports to supersede that, and it was passed in 1986, and it provides that if you go pretty much in a direct line from a place where you're able to legally possess the gun to another place where you're able to legally possess it, say if you were taking an ordinary rifle from Virginia to Maine, you can do that as long as it's stored properly in your vehicle, in locked containers and the ammunition and the guns separately. However, I should mention that some of these states that are very much against firearms ignore that federal protection, and this has been litigated, and the states have always won in those cases.
Oh my goodness. Well, that's something to be concerned about. We certainly want to ask the right questions before we get in the car and start, you know, traveling with that gun in the trunk of our car. I'm going to need to go to closing comments, guys. We're really running out of time here. So Ben, I'm going to come back to you for some final comments, you know, words of advice to executors on how to deal with probating guns, and for gun owners, how they might plan in advance to make that probate go more smoothly.
Sure. So the main thing is don't be afraid to bring in experts such as a federal firearms licensee, an FFL, or gun dealer to help you know what you have, and someone that is going to understand the rules very well as to how those items are transferred and how they may need to be secured, and they can just be a really invaluable resource.
And Dan, how about yourself? Some final advice, words of caution you want to share with our viewers?
Yes, the executor should take great care to store the guns safely and securely so that they're not stolen, so that children don't have access, that sort of thing. Just lock them up if you can. I'll just mention that actually Virginia has a statute that requires mandatory reporting of any lost or stolen firearms. So the executor should be very aware of that and be careful with those guns.
That's good to know. Dan and Ben, I want to thank you guys so much for taking the time to prepare for this show and educating me, because I knew very little about guns, other than I knew that they set off alarm bells in my head whenever I see them in a probate. Thank you for sharing your expertise. Great public service to our community and to all the people who are part of the Probate Nation. Thank you again.
Thank you, Richard.
Thank you for having us on.
You're very welcome. You know, I've probated many estates over the years, but recently have been seeing more and more probates that include guns. As I listen to the discussion in this show, it's clear to me that the presence of gun in an estate should be an immediate red flag to an executor. Actually, again, as we said at the outset, it should immediately set off one of those warning bells like you hear going off in an action movie when security is breached at a secure government facility. Can you hear it? I know that the story Dan shared about the risk you take personally in transporting guns across state lines to the beneficiary of an estate is a good example of why that warning bell should go off. So all of you do-it-yourself executors, beware, act prudently, and get legal advice if you find yourself probating any kind of firearm. In part 2 of Dealing with Guns, we will continue this discussion and then jump into some case studies to illustrate several of the rules we will have to navigate in probating guns. Friends, this brings us to the conclusion of our show. Hope you found it helpful. Replays of shows can be viewed on the Probate Nation website and YouTube channel. Until next time, be safe out there.